Welcome and thank you for joining SciFast's webinar, Energy Law Updates, Regulatory, Transactional and Litigation Trends, Part 1, Tariff Turbulence, Impacts on Energy Clients and Their Contractual Relationships. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. All unanswered questions will be followed up by email after the webinar. For those interested in obtaining a CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for a CLE credit. During the presentation, you'll also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. Copies of the program's recording and materials will be distributed to attendees in the days ahead. On the next slide, you will see a legal disclaimer. This presentation has been prepared by SciFast Shore LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or any legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn over to our first speaker, Annette Adalski. Annette, you may begin.
Thank you, Marianne, and welcome everyone. My name is Annette Adalski, and I'm co-lead of our Energy Transactions practice group. I'm excited to introduce you to our SciFast Energy partners today who are going to be speaking on part 1 of our 3-part energy webinar series. The moderator of today's panel is Ben Hughes. Ben is a real estate deal maker based in Houston who has basically seen it all: retail, commercial, industrial, and everything in between. Ben brings calm to chaos and structure to transactions, which makes him the perfect person to guide us through today's tariff-induced turbulence. Our first panelist is Susanna Bonham, our litigation strategist here in Houston, and courtroom calm in a tariff storm. Susanna is the person that you want to call when a contract dispute turns into a full-blown legal mess. With deep experience and energy, she's here to walk us through how courts are treating force majeure and tariff-driven disputes. Kicking things off from the corporate side of the house is Chris Cottrell, our corporate partner in Houston. Chris co-leads our energy transactions practice and has a unique talent for turning legal spaghetti into structured executable deals. He's helped clients buy, sell, and joint venture just about every type of energy asset you can think of. And he's going to show us how tariffs are reworking the M&A and commercial contracting landscape. Welcome, Chris. Rounding out the panel is Brenda Rodmacher, our construction partner in Los Angeles. Brenda brings nearly 3 decades of construction law experience and a resume that really reads like a global project map. Brenda knows exactly how tariff shocks ripple through EPC contracts, delay timelines, and blow up budgets, and more importantly, how to draft and negotiate around them. Brenda is here to help us avoid turning small problems into multi-million-dollar headaches, which some of us can relate to. So with that, I'm going to turn it over to my partner, Ben Hughes, our moderator.
Thank you for the introduction, Annette. For the agenda today, we'll begin with an overview of force majeure clauses and how they're adapting to include tariffs. Then we'll move through the specific impacts on engineering, procurement, and construction, known as EPC, operation and maintenance, frequently referred to as O&M, and supply agreements. We'll examine how contractual disruptions are leading to litigation, and we'll close with best practices for risk allocation and proactive contract drafting. This is a pressing issue right now because tariffs on materials like steel and solar panels are increasingly affecting project budgets, timelines, and legal strategies across the energy industry. These issues impact all stakeholders, from developers and owners financing projects to contractors executing them and suppliers providing critical equipment. The purpose of this presentation is to provide practical tips and litigation and help drive success in your businesses during these difficult and uncertain times. If at any point you have any questions, please type them within the Q&A box on your screen and we will address them as best as we can. Next slide, please. In the next slide, Brenda will examine how contracts are adapting, starting with force majeure clauses in the tariff era.
Thanks, Ben, and happy to be here with you all. I want to kick us off and start just at the basics. 5 years ago, nobody really knew what the word force majeure or phrase force majeure was. And, with COVID-19 and the ripple effects and supply chain issues, everyone really started to say, oh, what do I have in my contract? And started to look at these terms and provisions and understood. And force majeure now, I find is a phrase that people who you never would have thought understood now are familiar with. But with the tariff turbulence and the issues that we are currently seeing and the volatility of the markets, really it's an opportunity for everyone to re-examine and closely look at your contract language for existing projects, and then also as you're negotiating new deals and new projects, of looking closely at how you want to draft your language for force majeure, for issues of can we deal with the volatility by looking in our contract terms for protection, regardless of it. And one of the things that was really important to look at is, not only what is force majeure, but what are these issues that may be covered in what your existing clause is. Now, tariffs could be qualified if they're framed in the terms of a government action, depending again on the specifics of how your language is written and how the tariffs are being implemented and what happens. But tariffs fit into a really interesting way. One of the concerns that we have is courts are more and more narrowly construing language so that your clarity in how you're drafting the language of your force majeure provision is critical and important. It's very important at this time to go back, take a look. What does it say? If you don't have the term tariff in your force majeure provision, you probably want to include it and have something specific. We've got some different case examples. I find it interesting that we go back, 10 years ago for a case that's still good law, where we have a court in a kind of Sarah versus Hemlock case finding that tariff impacts were deemed insufficient. There was a case where a solar manufacturer couldn't escape a supply contract that because it had trade war language, the court still found trade war was not found to be an excusable issue for changing the terms of the contract. So we want you to really think carefully and really looking a real take home, go today, pull your contracts out, look at what the references are in your contract. Is the language for tariff included, trade policy, changes or supply chain disruption language? You want to make sure that you're looking closely and drafting your terms carefully. As you're looking at the new ones, think broadly, but you can't have too broad of language. You've got to have some of the specifics. With that, one of the things, the last thing we've seen is even what someone's called a Trump majeure clause, where you're looking at as the fluctuation. Is it the tariff is today and it's not tomorrow? What's going to happen and who bears the risk? One of the areas we're seeing a lot of clients work on, and I've had people ask me a lot about, is can we include in our contracts as we're negotiating now some type of renegotiation mechanism? So if there is a fluctuation in a tariff that hits a certain percentage or number, that would be something triggered. And we're going to talk a little bit more about that as we proceed. But Ben, I'm going to turn it back over to you to move us to the next topic now that we've laid the foundation.
Thank you for the background, Brenda. Now that we have covered force majeure clauses generally, we'll delve into how tariffs impact different types of energy contracts, such as EPC, O&M, and supply agreements, starting with Susanna discussing EPC impacts on the next slide.
EPC projects are particularly vulnerable as they often rely on imported materials like steel, solar panels, wind turbine components, and they have fixed price and fixed schedule commitments. Sudden tariffs can inflate material costs or cause procurement delays, threatening project economics and timeliness. Imagine a contractor building a solar farm under a fixed price EPC contract signed in 2024. And in 2025, a new tariff adds 20% to the cost of imported solar panels mid-project. The contractor faces a huge cost increase, and the owner is concerned about the timeliness of this project being completed. Who should bear the risk? The key contract points that we need to be focusing on and that come into play include change in law clauses, as well as fixed price risks, in addition to force majeure and price escalation. With respect to change in law clauses, consider focusing on, in an EPC contract, whether a tariff imposition could qualify, allowing a contract price or time adjustment. We recommend explicitly defining tariffs as a change in law to clarify. With respect to fixed price risk, many EPC contracts place cost risk on the contractor. If there's no adjustment clause, the contractor might have to absorb that tariff cost, a potential multi-million-dollar hit. But the owner is jeopardized with respect to the completion of the project. With respect to force majeure and price escalation, while contractors may attempt to invoke force majeures for tariffs, success depends on the clause language. In our experience, proactive price escalation or tariff adjustment clauses are a better tool to address and to negotiate on the front end. Things for you to be considering from a risk allocation perspective, because we're dealing with competing interests. Of course, the owners and developers want price certainty and timing certainty with respect to their project, and may resist the clauses that shift tariff costs to them. And contractors will push for the provisions to avoid being stuck with unforeseeable tariff expenses. It's a natural sticking point, and it requires negotiation and as much forethought at the beginning of a contract in what could be anticipated and developed throughout the project as delays occur. The practical advice is drafting and negotiating these deals and identifying those key materials that are overseas, internationally, that are limited in quantity, and including those key materials in contingency clauses. On to you, Ben.
Thank you, Susanna. That's really helpful guidance. However, tariffs don't just affect new construction. They also impact ongoing operations and maintenance agreements in the energy industry. Chris, please provide us some guidance concerning long-term O&M contracts.
Will do. Thanks, Ben. And thank you to everyone for joining us. I'm very excited to be here with you to talk to you guys about force majeure, or some of you in Texas refer to it, force major. No, I'm just kidding. So, operation maintenance contracts, that relate, for example, to power plants, renewable energy facilities, they can be hit by tariffs over their term, right? These agreements typically last, several years, and they involve supplying replacement parts, think specialized components, panels, turbines, and in some context, fuels. So if tariffs end up driving up the cost of imported spare parts or equipment, this may cause delay, as Susanna mentioned earlier in the presentation. And that can affect the uptime, and that can affect the performance guarantees. For instance, in a wind farm, an O&M provider might struggle if a critical imported component faces a new import duty or a trade embargo, and that could ultimately delay repairs and affect the runtime. So in a hypothetical, consider a 5-year maintenance contract where a wind farm is involved. The agreement's signed before a tariff comes into play, and the cost of the turbine blade goes up significantly. In year 3, that specific tariff doubles the cost of the blade, and it needs replacement because it's damaged. The service provider asks the project owner for additional compensation or time to source an alternative, right? What should the service provider look for in the contract? So, if you're a service provider, you got to pull out that O&M agreement, and the first thing you're going to be looking for is that cost pass-through clause. And does the contract allow you as a service provider to pass through the increased cost of the part? Perhaps within certain limits, right? Double the cost can really affect a lot of service providers, and that's something that's typically not forecasted. If not, obviously the service provider would have to bear the full brunt of that unless they negotiate a relief. A second provision, if parts are delayed or due to tariffs or trade restrictions, is there a force majeure clause or similar provision excusing performance, right? Service providers should ensure that their force majeure or delay clauses cover governmental actions, trade issues to protect them against breaches. In practice, parties might stockpile critical parts in advance of anticipated tariffs, and we've seen that recently across the news. Various business owners have been interviewed, and particularly steel people involved in steel manufacturing have indicated that they've been stockpiling parts. So that's one strategy. That's a practical strategy. It's not a legal strategy, but it's a practical strategy that could help you mitigate if your contract does not have a force majeure provision or a cost adjustment provision. So for energy asset owners, key concern for you guys is reliability, right? You want your O&M provider to have plans for tariff impacts, including alternative sourcing, stockpiling. So for service providers, long-term deals should include price adjustments to remain viable if tariffs spike. So we recommend inserting a tariff trigger where if the tariffs increase, X%, the parties will revisit in good faith and try to salvage the situation and come up with a solution that works for both sides. Another tip we have for in-house counsel, we recommend that you guys monitor your operational terms and as well as trade policies, work with outside counsel and engage counterparties early if a tariff is anticipated to impact critical supplies, right? Come to the table, have that conversation and come up with a solution before the tariff gets implemented. That's usually the best approach.
And
Ben?
Chris, I'll interject and say
Yeah.
one of the other tips in there, if you're looking at stockpiling and or other storage, you really have to take in to consider those costs and insurance related issues. So and who's bearing the risk of storing and maintaining the materials and the stockpiling. That's something that often gets overlooked. And then if there's damage to the stockpiled materials, you just have now added insult to injury on top of everything else.
That's a good point, Brenda. Ben?
Thank you both. Now that we have covered the construction and operational phases, Chris, in the next slide, can you please highlight tariff impacts on supply contracts more generally?
Sure. So this slide really focuses on the sale and supply of goods in the energy sector, right? Anytime you're purchasing things like a solar panel, transformer, even parts related to oil and gas facilities, every sector, especially the downstream sector, when you're thinking about refineries and turnaround projects, maintenance projects, every part of the energy sector is typically impacted by, a sales contract. So it could be a one-time purchase, right? Or it could be a long-term supply agreement. And suppliers and buyers face direct tariff costs on imported goods, which can erode profit margins or even make performance impossible if prices skyrocket. Tariffs or quotas can also limit availability of certain imports, creating shortages. So think of a situation where a U.S. energy company signs a contract to buy 100 solar turbines from an overseas manufacturer. After signing, a 30% tariff on those turbines is enacted. The supplier's cost to import rises dramatically. Will the supplier absorb the cost, try to raise the price, or claim an out via contractual clause. So the key provisions for such a supply contract, the first one we should talk about is the price adjustment clause, right? So ideally, this would include a formula or a mechanism for a tariff-induced cost change. An example of that is the price will increase or decrease proportionally with a new tariff on, X component, whatever component you're discussing. This makes the risk sharing explicit and avoids a fight later. There's also an emerging practice of a tariff clause, and sometimes we call this a tariff surcharge. And this is where parties agree upfront on how to handle any new tariff. So some examples, split the cost increase evenly. The buyer has the right to terminate if the tariff exceeds the threshold, or maybe another alternative is the seller can defer delivery. So these clauses effectively function as a bespoke risk allocation for trade policy changes. So if there's no price clause, the supplier might resort to force majeure or commercial impracticability claim, right? So without specific terms, those arguments are uncertain. For example, the UCC doctrine of commercial impracticability, I'm going to get that right eventually in this presentation, could be invoked if performance becomes extraordinarily burdensome, but courts set a high bar. So a mere cost increase often is not enough to discharge your duty or your obligation to perform, okay? We recommend clarifying in the contract whether a tariff is an excusable event or not to avoid defaulting to a legal debate or a fight. So some insights on negotiations. Buyers will prefer locked-in prices, obviously, where sellers want flexibility, right? And some accountability for situations like tariffs. So we typically recommend a balanced approach, such as capping the exposure for each side. So if a supplier, for example, a supplier could cover the first 5% of a cost increase, and anything beyond is renegotiated in good faith. So with that, back to you, Ben.
Thank you, Chris. That's really helpful guidance. Having covered how tariffs can affect project development, operations, and supply chain agreements, we'll now address broader project risk, such as cost overruns and delays that can result, and how clear contract language can help parties reach a resolution.
So I'm going to take this one on, Ben, being the construction side of the fence here. And it's interesting because, I think we see in construction related disputes across the board, whether they be in the energy sector or otherwise, the two key issues always are time and money, right? It's cost and time. Those are our two big issues in all of these types of cases. And when we have tariff volatility, it really what is we're seeing happening is exacerbation of one or both of those items. And Susanna and Chris really laid out for us a lot of the issues of what we can see in some of the contracts as ways to address and kind of manage those issues in your contractual side. But what we are seeing the consequences of the tariff volatility really coming and manifesting more and more with exacerbating and these repercussions on cost and time. Risk scenarios that we look at and we see, first taking a cost overrun. So, if you have a project where the materials, as Chris was just talking about, the supply impact, and you now you have an increase on the overall cost of construction for your project, your ROI for your project is potentially out the window. Contracts may not allow the price revisions or the negotiations if you haven't set it up ahead of time. And what that ends up doing is it's forcing everyone involved in the project to be in more conflict. So we are seeing increases of disputes and dispute issues litigation and the like coming up, when really ultimately turning these projects into becoming economically unfeasible. So it's one thing to say we're going to have a dispute and fight over the tariff and who has the 5% or who has the 8%, or if it's an impossibility defense or not. But ultimately, the overall project is going to be impacted if for cost overruns, and the viability of the project could be at risk. Similarly, schedule delays, right? You know, what we always say with construction is it's great if you can do it, but if you can't do it on time, you really have a variety of other issues, including potential consequential damages of not producing additional energy, if that's what your project is ultimately trying to do, or you have a timeline on different issues for your project. And so those delay challenges can be further exacerbated from tariff-related disputes and issues that are coming up out of it. So that can, you know, you've got not only the financial side of it, but also the practical side. So if with tariffs, if it's causing an impact and a delay of delivery of materials, if you're sourcing new materials to try to keep within budget, that can impact the schedule of the project. Again, then you're going to have to determine who's responsible for those delays, and your contract language really needs to be carefully looked at. And I think a lot of times, particularly in our EPC agreements, that's sort of overlooked. There isn't really a discussion had. So be looking at those items as well. Susanna, I'd love to hear from you a little bit on your perspective of litigation. I see some of these in litigation, but I think you have some interesting insights of what some of the fallout of time and cost issues and impacts from the tariffs.
Yeah, so, you know, what I'm seeing currently is just people coming to the table and needing to deal with these cost increases and these delays. And if only the dispute resolution provisions where the parties could agree to a expedited and restricted manner in order to get these to the table with a decision in order to move on so that the parties can go about completing the project. One of the recommendations that I've had recently for clients is an expedited and truncated and shortened arbitration process, with bringing to the table the amounts, the issues to the arbitrator in a 30-day, 60-day window, with providing the key documents, positioning each party's parts, and then moving them to a decision by an arbitrator in order to move on from it and not incur the litigation costs that we all know can consume these issues and last for a year, 2 years, or even longer than that.
That's great, Susanna. And I think that's spot on, and where we see with some of the dispute issues, where sometimes, like you said, the dispute can take over the rest of the issue and really, extrapolate these issues into something that paralyzes the project. And if you can think ahead, and I know a lot of times people don't like to negotiate the dispute process because they feel like that's calling that we are gonna have a dispute, but that's really why it's there. So you really want to think carefully through your dispute provisions. I think that's an excellent tip.
Yeah, and from the corporate side, separate side from courts, I think one tip I might add is, that these parties need to be thinking about, non-legal mitigation strategies like contingency planning, and having a process for procuring equipment or stockpiling equipment if tariffs are about to come, and especially putting that in writing. And so if the tariff gets triggered or there's a threat of a tariff, there's a process in place that parties have agreed to in advance, and there's a way to mitigate that.
Great. Yeah, from a construction perspective, your project could go smoothly, and you then aren't dealing with it. But we're seeing more and more, because of the tariffs, that there are these issues, and the more you can do to address it during the course of construction quickly is really to everybody's benefit. So Ben, back to you.
Thank you all. Now that the major risks are clear, contracts can proactively allocate these risks. Let's discuss how the parties should try to handle the shifting landscape through careful drafting and negotiation.
So the intent of this slide is really to function like a playbook for in-house counsel. And, you know, it how to allocate or mitigate tariff risks in contracts before problems arise. It essentially ties together lessons from earlier slides into actionable contract advice. So obviously we beat this one to death, but just say it one more time, be explicit in your clauses, you know, be very clear about the language and what your intent is, and exactly what happens if tariffs come into play. So this could be a force majeure extension, a price adjustment, termination right, like we discussed earlier.
Chris, I think you're right on, and I think, you know, that explicitness is what we've talked about with what your language is for your price escalation, if you're having caps or contingencies, and really being carefully looked at for your particular project. And I think a lot of times clients will say, we've used this on the last 5 projects, even if it's similar project parties involved. And it's really important to take a look closely at each project individually at this time and figuring out what those terms specifically should say for that project.
And additionally, another strategy to consider during the negotiations, and then of course, once you're underway in the project, are the procedural protections or clauses that require a party impacted by tariffs to give prompt notice and to mitigate damages. You know, it's the example of a supplier's cost jumps, and then they need to promptly inform the buyer, you know, of those price escalations, and then they've got to demonstrate efforts to find alternative suppliers or using existing inventory. It fosters transparency and can be a condition for relief. And so going back to your contract and making sure that you're aware of the notice provisions that you have and the obligations to mitigate on both sides of the project.
And one of the things that we've learned in my practice, I end up doing contract negotiations in the construction space in large part, and then litigation as well. And it's helpful to inform the other. And one of the things that we found really effective as a group is why we're all here today too, is really having our litigators work closely with our transactional team, so that as we're seeing these issues come into the disputes and in the litigation process, learning from that and helping to draft better and more complete contracts. You know, it's one thing to learn it from looking at what case law says, but it's another from actually going through the process.
I had a question for the panel. When addressing these types of issues, what is most important to know about the underlying business in your opinions?
Well, you know, in my view, it's really important to understand, have a clear understanding of the project, and probably the most important is the commercial relationship between the parties, right? And so, you know, striking a balance and having, you know, being intentional about your mechanisms for recourse and having practical, you know, look, it's one thing to write a contract, but from a practical perspective, these parties typically have to continue to work together to get things done. Often, even after the project's completed, right, they've got to continue to operate and maintain these projects. And so being thoughtful about the business and the relationship, I think is those are key things in my mind.
I also think that really understanding the contract and it's what it's going to take to complete that contract, because you need to be identifying the key materials, right? And where are those key materials going to be coming from? And what could happen in the future with respect to, you know, the quantity, the inability to get those materials, and how you're going to be addressing that at the beginning of the contract instead of as you find yourself at the end of the contract without being able to complete the project.
Yeah, and I'd add on to that. I think it's not as much about the specifics of those are all important, but also the communication. And it goes to some of the issues of knowing and understanding the contract, knowing whose obligation is to do what, knowing what the notice requirements are, but then talking about it, as part of the negotiation that you're really saying, how are we going to communicate about these issues? How are we going to know? And I think it's changed a lot, and with the volatility of the tariff situation, you can't sort of say that's your job and let me know when you're done. You really have to have that integration of the different players with the owner and the developer, with the contractor, with the supplier, and really knowing what's happening, and that's really kind of creating and hopefully it's a positive thing. I think this is, we've been talking about all the negative here. It's a really hard situation to have to deal with it, but the positive of it is hopefully you actually are going to be able to build better, more effectively your projects, because your communication is going to have to be increasing and have to have a lot more integration with each other.
Brenda, you may have touched on my next question, but a lot of our audience is in-house counsel. And in light of that, I wanted to ask, what can in-house counsel do when assisting outside counsel with these matters?
Well, I think is giving us information at the outset as much as possible, and not assuming that we know the background to the negotiation is probably really important, particularly at the outset. If it's a litigation matter, and Susanna can probably talk more on that as well, but again, is giving us the information as much as we possibly can have it, because that's tools for us as outside counsel to do our best and to give you the best analysis and advice.
Another tip, I guess, a practical tip I would give, this is really, to Brenda's point about, spinning this in a positive way, this is really in-house counsel's opportunity to solidify a commercial relationship and be a representative for their organization. And so, coming to the table and making the negotiation as, not only as practical, but as pleasant as possible, trying to be constructive and flexible, and to open up the conversations, to think outside the box and come up with solutions that maybe you haven't considered in the past. I think those are really important things. And, that you could build a lot of value if you end up being viewed as a counterparty that's easy to negotiate, and flexible and great to work with.
Thank you all. Now that we have covered risk allocation strategies, Susanna, can you please discuss what happens when disputes do arise?
Despite best efforts in drafting, tariff impacts will lead to a wave of contract disputes. There's no question about it. And courts have generally held that economic hardship from tariffs alone is not enough to escape contract duties. Additionally, fixed price contracts are generally construed as assigning the risk of cost increases to the seller. And courts often reject a force majeure defense based on tariffs, unless the force majeure specifically addresses tariffs. One case, although not tariff related, that I'm keeping a watch on as we kind of move through this topic and this issue is MICO LLC versus Pioneer Resources USA Inc. It went up on appeal, and it's back down for trial again. The issue was a force majeure clause, and the court narrowly construed that force majeure clause, as they typically do. But what was critical about it is that the parties had negotiated and included within that force majeure certain language that really did play to some of the circumstances that they needed to be anticipating. In that case, it was the question was whether an entity needed to go out when they couldn't provide their goods due to a freeze, whether they were obligated pursuant to the contract to go out and buy someone else's goods in order to do the spot market. And the language of that contract actually did afford protections to that one party. And it's just something that I would highlight. Again, it's the focus of, at the beginning, assessing your risks and identifying the key materials, the key obligations of the parties, and negotiating in advance for how an issue is going to play out. Because if you don't, what you're going to find yourself doing is calling me or calling Brenda, and the cost of that litigation may dwarf the issues at hand. So on to the dispute resolution piece that I want to focus on. Some other things to think about on the negotiation side, because you'll be calling me on the dispute resolution side, is whether your contract has an arbitration clause in it. Number one, it's what we're finding is that juries do not understand these issues. And when they start seeing these numbers, they don't like either party at the table when they're having to decide. And so selecting and moving this over to arbitration is really a good idea, number one. You then have control, number two, in order at the beginning of a contract to limit the discovery for that case in order to get you to a decision quicker so that you're avoiding even more litigation costs. Additionally, something else to be thinking about is ensuring that that arbitration provision has confidentiality specifically and expressly included within it. Because in fact, arbitrations are not confidential without that provision being included. Additionally, trying to evaluate the process, right? To mediate, to require mediation, what levels of mediation would be required in order to get you to your next place. And then, of course, forum selection and governing law are critical because depending upon the state, the law on force majeure may vary drastically. And then, of course, at the end of the day, ensuring that you have the evidence to have complied with the notice provisions within the agreement and have the evidence to show that there was due diligence and reasonable efforts in order to mitigate. On to you, Ben.
Thank you, Susanna. We're going to conclude with a few key takeaways and concrete advice for stakeholders moving forward.
So for in-house counsel, my recommendation for all of you is to stay proactive. Regularly review your company's contracts for tariff exposure, implement internal alerts for new tariff or trade policy changes, and assemble a response team, which could include legal, procurement, or finance, to address potential impacts swiftly. The idea here is really to be the bridge between legal and the business side, and turn that into action to ensure that what you learn is applied company-wide.
Because I would jump on that, and one of the things that I think what in-house counsel can do to really help mitigate and reduce some of the tariff risks is to be proactively engaging with the operations side of the house and knowing what the deals are. I know a lot of times it's hard because legal is often seen as the roadblock and the stumbling block to moving things forward. And I think it's really important to have that as a continuity involved, because these issues will come back and will severely impact the project as a whole. And so what you're saying, with in-house counsel being that bridge on those issues and helping your operations teams understand as they're negotiating contracts and as they're working on the deals, that these are issues that should be discussed early on, and understanding why. I think also the in-house counsel can explain why some of the terms that we're recommending need to be in your contracts. Because a lot of times people don't understand that and they think that it's really not necessary. And so those are some other things I think that in-house counsel really can effectively do to help staying ahead of some of the tariff risks and educating, as you're talking about educating our teams.
And then, of course, the more that you negotiate on the forefront at the beginning with respect to the force majeure clauses, and taking into consideration whether you want to be, talking about tariffs or not, know in advance that what you're going to be doing is you're going to be limiting or reducing your litigation spend if you've addressed it now before you enter into the contract. And then, of course, mine is the critical to do the risk assessment of the materials and all the way down to the subs, because it's the sub of the sub that you didn't know was going to be providing the material, that you need to be making sure that there's a provision to address that when they can't deliver because they don't want to incur that cost because they didn't factor it into their bid.
Yeah, and so on the developer side, that's a great segue for the operational side. So, allocate your risk, right? In new projects, insist on clarity in your contracts about tariffs, either fixed price with contingency funds or share risk via clauses. Maintain open communication with contractors and suppliers. To Susanna's point, early collaboration can prevent disputes. Consider the political risk insurance. I mean, that's a new thing that's coming to the market as this continues to be an issue across the industry. There's new products coming out every day, so definitely stay plugged in with your insurance providers. Also, there's hedging strategies for critical parts, so just keep all the different options in mind. Do you guys have anything to add for developers or owners?
And I would also add, and I just throw this out there for those of you as in-house counsel, when you're looking at these agreements and the dispute resolution provisions, including that timeline and including that limited discovery so that the arbitrator is armed in order to limit the process so that you can get to a decision that factors in a more limited cost of the litigation than what I'm currently seeing in most arbitration agreements. The fact of the matter is that doing a shortened, timeline, especially if only with respect to escalation of costs, it would drastically reduce your litigation budget with respect to this issue.
Yeah, and I think that goes 100%, Susanna. I agree with it. It goes to all parties to these agreements and these projects, that looking at it, it's not really to the benefit of one or the other. It's really to everyone's benefit to have clearly negotiated dispute resolution terms. And I think one of the worst things that I see in contracts is when someone has either a template agreement or they just say, we'll submit our claim to dispute or any dispute to arbitration, check the box. And that's it. That's all that's in there about your dispute resolution or your arbitration. And we often see where people run out of energy or they don't want to negotiate on the dispute resolution terms because somehow that feels negative, and we're trying to be positive at the outside and the outset of a new project. But it really helps, as Susanna was explaining, on the back end, that you have thought through carefully, if we have a dispute, how are we going to handle it so that it is most efficient and effective for everybody and for the project as a whole.
Yeah, I think that's a great point.
We're happy to provide you with some examples of our recommendations to limit it, to make it short and sweet, but get both parties to that end result in a fair way.
Yeah, and I think just to add to what you guys are saying, if you have recourse contemplated, it's good to have a practical approach to everything. So, for example, if you have certain permits that need to be transferred in the event of a breach, right? Having some of those transfer notices signed and held in trust could really allow the party that's enforcing the remedy to submit the permit transfers, the regulatory transfers. So just kind of thinking through some of the things that you might actually need in order to step in is a practical tip that I would give.
That's great. I think for contractors, some of those same issues we've talked about apply, and there's a few other issues that come up. In particular, really looking closely at your bid and what you're including and what contingencies that you're accounting for, thinking of and looking carefully at the potential upsides and downsides of tariff risks, and whether you have a price fix contingency or some other type of approach. That's something that contractors really need to look closely at. And also looking for considering, like we were talking about, what other insurance that may be available for contractors along these lines. We also are seeing, with contractors, if you're hit by tariffs, making sure, as Suzanne had mentioned, making sure you document it really carefully, that your team knows before there's a problem of how they're supposed to be documenting. The same thing goes for your delays, that you're coding hours by employees that are doing additional work or things along that line to address your delays, so that you can really properly make your claim as a contractor in those situations.
Yeah, that's a great point, Brenna. So we've been talking about documenting things, and that's great for new contracts, but for existing contracts, if you're a contractor and you're hit with a tariff, right? Don't overpromise on price. Make sure you engage your counterparty early, and that you document all your efforts. And if your contract doesn't have a provision, you can default to equitable principles and have those types of conversations. On the equipment side, it's important. The supplier side, again, having the open conversation with your customers, letting them know that there may be tariff exposure, that it may be coming, and that the price increases are coming accordingly is an important thing to consider.
There are a few questions that I'm reading through to see if we can't answer some of them quickly as well. Apologies for the delay.
There's quite a few good ones, which indicates the interest in this topic. One that I'm enjoying is the question: have you seen success with using dynamic indexing mechanisms like steel indices or commodity-based escalators to allocate risk in a way that is fair but enforceable?
Yeah, and I'll jump on, start with that and make a comment. Is I've seen that, and I think that's one of the areas where I've seen successful contract negotiations is when you are negotiating your price escalation clauses, that you tie those increases to an index, and that the parties agree to a particular index that's objective. And that really helps in your dispute later, because you've tied it to an index. And therefore, it's something that the trier of fact can say, that's the index, that's the price, this is what you negotiated. It's very clear, and there is less ambiguity. So I've seen that very successfully used.
I have mixed reviews on that. So it depends on the index you choose, right? So on the upstream side, COPUS is something that's often referenced in joint operating agreements, and that's great, but the adjustment happens once a year, and so it may not be an immediate adjustment. So just be careful about what index you reference and what the timing is on those adjustments.
We can absolutely share some examples for those that have asked of suggested clauses.
Another question that I have a personal interest in is how are lenders responding to tariff-related cost escalation risk in project finance documents? Are there any trends in buffer requirements or contingency structuring?
Well, I mean, on the lender side, obviously that is continues to be a concern. So, practical things that they're asking for are bonding, guarantees. Insurance is also something that we've seen. Tighter mechanisms around when funds are released, right? The timing of the release of those funds. So typically, lenders are expecting, if they're paying for equipment, they want to see it delivered. If they're paying for materials, they want to see it delivered and on site and ready to go. And so a lot more focus around actual delivery and performance as a result of these tariffs.
And then a more detailed cost review, right, for these projects is absolutely anticipated as a result of what's occurring around us right now. In addition to higher contingency reserves are being required is what I'm understanding because of the fluctuation in pricing and the concern of jeopardizing the completion of the project.
Yeah.
Timing wise.
At the end of the day, more equity solves a lot of problems, right? So lenders are less willing to provide debt in these types of situations. So there's an adjustment for that.
Thank you for all the great questions. If we're not able to address your question, we'll be glad to reach out to you in the near future to discuss. So this presentation is eligible for CLE credit. To obtain credit, please scan the QR code on the screen and you'll be taken to an attendance verification form. To complete the form, you'll need the verification code SS, that's as in Sam 7895, and the title of the program, which is Tariff Turbulence. We'll give everyone a moment to do so. And once
That
again,
may also be Cypress Shaw.
yes, good point. So once again, the verification code is SS as in Cypher Shaw 7895. Right. Hopefully everyone had a chance. If not, the slides will be distributed to the attendees, and the ability to scan will be present once again. So we wanted to thank everyone so much for attending. We're as happy to connect with you informally, whether you have general questions or are looking for broad strategic guidance. Please feel free to send any of us an email or give us a call. Through careful planning, energy companies can transform our current tariff turbulence from a disruptive threat into a source of resilience and even potentially a competitive edge. Thank you very much.
Thanks, everybody.